Good afternoon. It's 5:15, and this is the the Jefferson City Planning and Zoning Commission. This is the June 13th meeting of the Planning and Zoning Commission. My name is Chris Yarnell. I'm the vice chairman. Mr. Jordan decided he could not be with us this evening, unfortunately. I'd like to remind everybody to, when you come up to speak, turn on your microphones and ask that you please silence all of your phones and other electronic devices. Let's start off by introductions.
Carlos Graham, City Council and Liaison to this Commission.
Michelle Mahoney.
Mike Lester.
Jack Deacon.
Penny Quigg.
Chris Yarnell.
Blake Marcus. Dean Dutoy.
Bunny Tricky Cotton.
Hank Vogt.
Eric Barron, the Planning Division Manager.
Anna Naniski, City Planner.
Ian Solinger, City Planner.
Sonny Sanders, Director of Planning Protective Services.
Brian Mulford, City Staff.
Shane Wade, City Staff.
Beth Sweeten, City Staff.
And we would like to welcome our newest alternate, Emily Fretwell. Congratulations, I think. Okay, procedural matters. The city code authorizes 9 regular members and 3 alternates. Alternates are designated to vote upon the absence or disqualification of regular members. A quorum of 5 members or alternates is necessary to conduct business. I declare that a quorum is present. We have 1 member not present, 2 members not present, because Mr. Vaughn's not showed up yet. Chris Jordan and Dale Vaughn are not present, so we will have Hank and Penny vote. Emily, we welcome your conversation, but you don't have to vote today. Thank you. Call for cases. Case number P190163215 Masonic Court, preliminary PUD. We have somebody here for that one? Thank you. Case number P19017 Zoning Code Text Amendment pertaining to medical marijuana dispensary facilities. And you guys have that one tonight, right? Very good. Do we have any requests for continuance?
No.
Any reason to reorder?
No.
Ian, would you please read the format of the hearing and the order of testimony?
Thank you, Mr. Chair. I would like to briefly describe the procedures of the Commission. The proceedings of the meeting are being recorded, so please step forward to the microphone when you speak and give your name and address for the record. The standard order for each case is as follows. After introduction of the request by city staff, the applicant or their consultants will provide information on the request. The opening presentation by the applicant shall be limited to 10 minutes unless additional time is granted by the Commission. The applicant shall have 3 additional minutes for closing testimony if requested. We will then ask to hear from supporters of the request. We will then ask to hear from opponents of the request. We will then ask to hear from anyone else who wishes to speak on the request. Testimony shall be limited to 3 minutes each unless additional time is granted by the Commission. City staff will then make their recommendations on the request. In order to reduce the time necessary to hear an application, references to printed material including staff reports and applicable findings shall not be read into the record unless directed by the Commission. The Commission will close testimony from the floor. The Commission will then discuss the proposal, then publicly make its determination with reasons. The form of the motion shall be positive, that is, the motion shall be made to accept the request as presented or with modifications, stipulations, or conditions. A final vote will be taken with ayes in favor and nays opposed. The chairman shall announce the results of the vote, specifying the number of votes cast in favor and the number of votes cast against. The following documents are entered as exhibits for all items under consideration at this meeting: the City Code of the City of Jefferson as amended, the Comprehensive Plan and Land Use Map, copies of applications under consideration, a list of property owners to whom notices were sent, the affidavit of publication of the public notice in the newspaper, copies of drawings, plans, and/or renderings under consideration, letters or memoranda from staff, staff reports, minutes of proceedings, correspondence or other materials submitted by the public or the applicant, rules of procedure for the Jefferson City Planning and Zoning Commission. These items are public record and available for inspection in the Department of Planning and Protective Services or through the Office of the City Clerk. Please be advised that any items that are presented, distributed, or otherwise received pertaining to the cases under consideration become the property of the Commission. This includes photographs, drawings, petitions, and letters. Thank you, Mr. Chair.
Thank you, sir. May I have a motion to adopt the agenda as printed or as printed?
I'll second that.
All in favor? Any opposed? Thank you. May I have a motion to approve the regular meeting minutes of March 14th, 2019? No, that's not right.
That would be the minutes of May 9th.
May 9th, 2019.
Move to approve May 9th, 2019 minutes.
Second that.
All in favor? Any opposed? Okay. We have communication, correct?
Yes.
If we want to take just a minute to peruse that. Okay. Case number P19016-3215 Masonic Court preliminary PUD. Who's here to present that?
Well, and if I may, Mr.
Sure,
Chair,
go ahead.
I'll introduce the case and let Mr. McMillan go from there. The property is located off of the intersection here of Truman and Masonic Court. And for your reference here, this is North 10 Mile and the intersection of West Truman. To the north, you have the Public Schools Retirement Building, Public Schools Retirement System Building. The property is located at the end of Masonic Court here. The property was annexed into the city in 1967 and has been zoned PUD or planned unit development since 1985. And it's surrounding zoning of residential single family to the south and to the east. The use of the property next to the east is as a cemetery currently, and to the south as single family residential.
Are there any? I'm sorry.
No, here we have a air photo of the property. There are two features of the property that are important to note. You have a power line that's kind of hard to see here that travels along the north branch of Wares Creek, which is here. And here we have a site plan displaying the parking lot. The applicant is proposing to construct a 100-space off-site parking lot to serve their current facility, which is on the corner of Masonic Drive, on the southwest corner of Masonic Drive and West Truman. An important feature of the PUD plan is the sidewalk over here that connects the property that it serves to the parking lot itself. The building that it serves is here. Yeah, and if you look here, the what was provided here, the visual that was provided shows that this air photo is outdated as 2015, and since then there's been a daycare that has been built between the two properties. The applicant's consultant is here to present and answer any questions, and I would be happy to answer any questions as well.
Does the commission have any questions for Ian? Okay. Seeing none. Who would like to present the case?
I'm Brian McMillan with Central Missouri Professional Services, 2500 East McCarty Street. And here on behalf of Rose International, the prospective buyers of this property and the people who want to develop the parking lot. I will say that Mike Henley is here with he's with Rose, and he can answer any questions should you have any about for them. Greg Bowman is also here, I believe, representing the current owners of the property that will be selling it. So, if there are any questions of him. So, anyway, Rose has been here over 20 years. I think maybe around 23 years. And they provide IT staffing around Jefferson City and actually all over the world, according to Mike. And so they've been a big part of our community here, and they're really growing. And they've pretty much filled this building with staff and have a huge need for parking. And so that's the reason we're wanting to do this parking lot. This lot is perfect for it. It's just down the street, and I think it's a really good use for this lot. We're basically using barely half of the lot, and mainly because the back part of the lot is kind of cut off by the creek and by the power line, as Ian mentioned. And so that provides a really good buffer to the residences up behind there. So anyway, it's actually fits really good with this area. So. Beyond that, I'll be happy to answer any questions you may have.
Is there a change in use of the property, the building?
The building will not. Their current building up on Truman Boulevard, I don't think will change the use. It's still what it's been. It's just grown. So and they're not adding on to the building. They're just have more people in it. And I think some of the neighbors will be happy about that too, because I'm sure some people want to sneak into some of the empty parking spaces in neighboring lots, so this will be really good for that.
Any other questions for Mr. McMillan? Okay. Thank you, sir. Is there anyone here would like to speak in favor of this request? Okay. Seeing none. Is there anyone here who would like to speak in opposition of this request? Seeing none. Is there anyone here who would just like to speak upon this request? Okay. Seeing none, we will close testimony. Ian, could you please give us your report?
Yes, thank you, Mr. Chair. With the proposed sidewalk connecting the proposed parking lot to the site of service, the plan meets the requirements of a preliminary PUD plan, and staff recommends the approval of the preliminary PUD plan. Thank you.
Shane, do you have anything you want to add, sir?
I can briefly go over the infrastructure and site improvements. As far as drainage goes, it's proposed to treat the stormwater from the new parking lot with stormwater to address the stormwater quality requirements. As Ian and Brian had both indicated, there is a sidewalk that's to connect the building to the new proposed parking lot. There's also been an area back near the creek area to provide a possible future greenway area in and around the riparian corridor of the creek. Utilities also are in the vicinity in the event that they are needed for the new parking lot. The owner may want to consider adding a street light at the end of the cul-de-sac. There is a existing fire hydrant there now. There is, unfortunately, no street light at the end of the street, so if interested, they could participate in our street light addition program that we have. and that we would also support approval of this request.
Thank you, sir. Do we have any commission questions for anybody?
Shane, if they do put their own lights in this parking lot, will it be directional lights so it doesn't light up the sky?
They would have to follow our lighting
Okay.
code in the zoning code. What I was referring to was the actual street light at the end of the street.
Anyone else? Okay.
Well, I won't be able, it's just a picture. That one should be good. The residence, I believe, is one of either of these two here. And I was able to speak to them today about their questions and concerns, and feel that I have addressed those.
Okay. With Mr. Vaughn appearing and joining us, I believe that means you're not voting right now. Luck of the draw. Okay, thank you. Any more questions? Would someone like to make a motion?
I move that we approve the preliminary PUD plan.
I'll second that motion.
Any questions? Any discussion? Okay, all in favor of the motion? Any opposed? Don't think we need a roll call. Okay, the motion passes. We got that one done. Okay.
And Mr. Chair, if I may, this will be presented to the City Council for approval on Monday, July 15, at 6 p.m. here in these chambers. And it is also a public hearing.
Thank you. Okay, on to the next one. Yeah, right. Thank you. I'm up. Best keeping me straight up here. Case number P19017, zoning code text amendment pertaining to medical marijuana dispensary facilities. Anna.
Thanks. Oops. Okay, sorry. I'm so used to looking at that one. So the purpose of this text amendment is to incorporate medical marijuana dispensaries into the... Sorry, what? Am I talking loud enough? I'm sorry, guys. Is to incorporate the medical marijuana dispensaries into the Jefferson City zoning code. Medical marijuana was approved by the November 18th amendment to the Missouri Constitution regarding medical marijuana. City staff has incorporated these uses into the Jefferson City zoning code in 2 phases. This was to incorporate these brand new legal uses into the code slowly. Phase 1, that involved the land use regulations for cultivation, processing, and testing facilities, and that was passed by City Council on June 3rd. And now we're in the second phase, which addresses the land use regulations for the retail use, the dispensary facility, and a few other additions that were incorporated by the state since they finalized their rules and regulations on June 4th. So the Missouri Department of Health and Senior Services, they are responsible for all licensing, regulating, and monitoring of medical marijuana facilities. The local municipalities, we can establish some land use regulations for these medical marijuana facilities. There are now 5 different types of medical marijuana facilities: the cultivation facility, the testing facility, the infused products facilities, and we covered those in phase 1. And now we're here to talk about the medical marijuana dispensary facility, again, the retail use, and medical marijuana transportation facilities, which they distribute medical marijuana to qualified patients and to other certified facilities. a medical marijuana dispensary would be permitted use in the C2 General Commercial Zoning District. They would be prohibited in all other zoning districts. The medical marijuana dispensary is naturally commercial in use, in nature, with other retail services and sales, including pharmacies, liquor stores, and tobacco shops, also being allowed in that district, as well as personal services and healthcare facilities. The medical marijuana transportation facility would be a permitted use in the M1 and M2 zoning districts. So M1 is light industrial and M2 is general industrial. They would be prohibited in all other districts. The medical marijuana transportation facility is industrial in nature with distribution facilities and wholesale sales, which includes like indoor operations and storage. They are also permitted in the M1 and M2 districts to show some comparable uses. So there are two specific use standards for the medical marijuana dispensary and medical marijuana transportation facilities. These are the same that were proposed for the cultivation, infused products manufacturing, and testing facilities. As specified by the regulations outlined by the Missouri Department of Health and Senior Services, no new medical marijuana dispensary facility or transportation facility shall be located within 1,000 feet of any then existing elementary or secondary school, child daycare center, or church. And also, any medical marijuana facility licensed by the Missouri Department of Health and Senior Services has to comply with all of these state requirements, regulations, and procedures. So this is next I'm going to show you two different maps that are going to show you how staff analyze how this 1,000-foot separation would affect properties. So this map, in regards to the medical marijuana dispensary facility, highlights the C2 General Commercial District with a 1,000-foot buffer around churches, daycares, and schools. In regards to the medical marijuana transportation facility, this map highlights how properties that are M1 and M2 would be affected by the 1,000-foot buffer around schools, daycares, or churches. So now I'm going to get into a set of diagrams that illustrate how the 1,000-foot separation is determined. And this is, again, per regulations determined by the Missouri Department of Health and Senior Services. And the diagrams I'm going to show you are not to scale. So there are 4 different ways in which the separation can be determined. They are described from the perspective of the medical marijuana facility. So for a freestanding medical marijuana facility, the 1,000-foot buffer is measured from the external wall of the medical marijuana facility to the entrance or door closest to that wall of the school, daycare, or church. So you can see here, it is wall to property line. You said, yeah. Okay, I'm sorry. For a freestanding medical marijuana facility, the 1,000-foot buffer is measured from the wall of the medical marijuana facility to the property line of the school, daycare, or church. For the freestanding medical marijuana facility compared to a school, daycare, or church that is within a multi-unit structure, the 1,000-foot separation is measured from the external wall of the facility to the entrance or door of the exit of the school, daycare, or church. So with this one, you can see wall to door. For a medical marijuana facility that is within a multi-unit structure, then the measurement, the separation, is determined by the door of the medical marijuana facility to the property line of the school, daycare, or church. One more. 2 multi-unit structures, both the medical marijuana facility and the school, daycare, or church, this 1,000-foot separation is determined door to door. Correct. So as identified by the Missouri Department of Health and Senior Services, this measurement shall be made along the shortest path between point to point, all those things that I just described, that can be traveled by foot. So again, the purpose of this text amendment is to incorporate medical marijuana uses into the Jefferson City zoning code. Per the 2018 vote, these uses are legally allowed to operate within our city. This is just our opportunity to have some control over where they might go, just as we have illustrated in this proposed text amendment. Thank you.
Okay. Is there anyone, do we have any questions from you? The staff have any questions? Dale?
Can you elaborate on the by foot? Is it, I saw in there, Jim, what was the term used? D something.
Yeah. So
demarcation?
Yes, it basically just means by point. That is the language used in the rules and regulations from the state, and it just means the shortest path from this determination.
Would that mean?
It doesn't mean like as the crow flies.
So not in a straight line technically, but okay. Imagine you're on a sidewalk. You have two sidewalks.
Mm-hmm.
I'm imagining let's say Missouri Boulevard, and there was a crosswalk somewhere. Are we talking about from the sidewalk to the crosswalk over where you would cross, then the sidewalk back? Or are we talking about straight across the road? It is walkable, but is it? You know what I'm saying?
I do.
Can I add on into that, Dale?
Sure.
I did notice that in our deal under subsection, what would that be? 36B C, no, B1C. We said that can be traveled by foot, but the DHSS regulations say can be lawfully traveled by foot. And I think that would solve your question if that was in there. So is there a reason why we kept the word lawfully out, or is that just we waited? Because I think that does make a big difference. If you can travel it by foot by walking across Missouri Boulevard, you're still jaywalking.
Right. Or if you're diagonal across. I mean, I guess it would mean...
Right, if you're talking about a diagonal crossing.
You wouldn't be able to walk as if there was a structure in front of you. Other
Right.
than that, straight.
Yeah. Or if you could trespass across someone's lawn or something like that. Yeah, so if lawfully is in there, I think it kind of changes it quite drastically.
We'd probably respectfully request that to be included in a motion. Fix that little problem.
Any other questions from the commission?
Oh,
Comments?
I just had one other thing, and I hate to be the guy who brings this stuff up. On the church, school, and daycare, I assume those are our city code definitions as opposed to DHSS's definitions. Is that right?
What do you mean?
Yes, they would be, because it's within our zoning code, so it'd be as the zoning code defines them.
Okay. Is there any concern about our ordinances, and I haven't looked to see what those definitions are, but is there any concern that our ordinances would be more restrictive than DHSS regulations? Because I think DHSS requires it to be a licensed daycare, and we say daycare center, which has our own specific meaning.
Yeah. And so I think we considered this and came up with we're probably less restrictive.
Okay.
In the proposal because we're dealing with that specific land use of a daycare rather than what you said, that licensed
Right.
Facility.
Perfect.
But I don't envision the impact being too great.
Good.
So.
And then the other question would be, under the DHSS rules, we're allowed to make it less restrictive than the 1,000 feet distance. Is there a reason why the city chose to stay with the 1,000 feet as opposed to making that less restrictive and potentially bringing in more dispensaries or even a dispensary, which may be pretty prohibitive right now with a 1,000-foot buffer?
As a proposal, we figured that it would be a pretty good starting point to propose it. It's the same as the state has outlined. We have not received a plethora of comments on this, but the comments, one comment at least that we have received was a recognition that the person commenting would like to see that the city not reduce that 1,000-foot separation. So,
If I may, I don't know how long you've lived here, Blake, but that's just the way it is here. We're lucky to get 1,000.
Back to the measuring part of it, who actually does the measuring? Would that be like a staff member? Is there certain guidelines on how you measure that? I know it's lawfully, but who actually does the measuring?
and so as being an item within the zoning code, it would be city staff that would be responsible for enforcing that. So.
And then in C1 zoning district, are pharmacies, liquor stores, and tobacco allowed in C1 zoning?
Liquor stores are only permitted by conditional use permit, and so that's some of the thinking that went into leaving it out of the C1 district.
And I'm assuming that's also state guideline too, as far as C2 being in C2 zoning district.
No, the state doesn't have zoning, so there's no guidelines
So
to
there's no
match.
recommendation
So
or anything.
yeah, all zoning is done at the city or county level. So.
Okay.
Anything else? Seeing none. Is there? So now we would turn around to present the case, but you've pretty much done that.
Staff recommends approval of the zoning code amendment. We are going to work through this with 2 motions, or do you want 3 now with the lawfully?
So the state finalized their regulations after the packets went out, and so the final version had some slightly different language, which Anna has presented here, and it's what would be its final form if approved through this body and then on to the city council. But because some of that final language came out after the packets went out, we had to split the thing into 2 pieces. And basically have you all vote on what was publicly put out there as part of the P&Z packet, and then vote as an amendment to that to make it align with the state's final language for their regulations, because we've always been upfront that we are proposing this from the staff level to be in line as closely as possible with what the Department of Health is putting together, and we want to keep with that. And then added on top of that is the one word, unlawful, the unlawful word to be inserted in there in the proper location.
Okay, but I think we still have to have. I assume I still need to open this up for comment, correct? Okay. Is there anyone here who would like to speak in favor of this request? Seeing none. Is there anyone here who would like to speak in opposition of this request? Seeing none. Is there anyone here who would just like to speak on this request? Please come to the microphone. State your name and address.
My name is Greg Bowman, Bowman Realty here in Jefferson City, 1002 Diamond Ridge. First, I want to thank the council, City Council Planning and Zoning, for moving as quickly as you are with this, because it's a very hot topic and things are moving rather quickly. And I commend you all for everything you've done at this point. The only topic of conversation I would like maybe for you to think about is maybe a conditional use in the C1 zoning. Jeff City's really limited for locations under the C1 or C2 zoning at this time. The churches, the staff's done a great job outlining the locations and stuff, but whether you know it or not, we don't have a whole lot of space available in Jeff City for these types of businesses, these pharmacies. And it's exactly what it is. It's a medical marijuana pharmacy, basically. Called a dispensary, but it's a pharmacy. And people going into these places are people that will have cards to get in and need the medical drugs, whatever you want to call it, for their illness. And we want to try and make it as simple and easy as we can for these people to get in and out of these places. And Missouri Boulevard is not that easy all the time. And right now, that's about the only place we're finding locations to put these things. C1 opens up several more locations and areas closer to the hospitals, closer to the clinics, where as a conditional use would still allow you to, yes or no, approve it. Same thing with convenience stores, C1. They sell liquor, they sell tobacco. It would open up a little more area and still create landlords to move their property, increase businesses, give us more choices to choose from as locations. Still keep your 1,000-foot buffer. I think that's great, the way you've done that. Every town's doing it different. I've been all across the state, and I don't think there's any two alike, really. But my point is, if you would discuss it, I'd like to know your thoughts on it as a conditional use in a C1 zoning. Thank you.
Thank you, sir. Oh, Mr. Bowman, hold on. Does anybody have any questions for Mr. Bowman? Okay, thank you. Okay. Anybody else who'd like to speak? Seeing none, we will move forward. Are there any more questions from the staff at this, or for the staff from the commission at this point?
So did the staff discuss that type of proposal of conditional use in C1 for dispensaries?
It was thought about, yes. The C1 district is actually titled the neighborhood commercial zoning district. The way it's laid out in the zoning code, it's the type of district that is more often, at least as far as it's laid out in the zoning code, closer to residential areas. I can understand perhaps the need for more property or the desire for more options out there. We believe that yes, there's a lot of property that would be restricted from this use based on the 1,000-foot measurement. Not as much as shown up on the screen, because the manner and the method of measurement is very difficult to map. We believe there would be a lot of property that would be available. That there would be plenty of options for this type of business to locate within Jefferson City. But the C1 district is getting into a lighter level of commercial, and this being especially a brand new use, we do not know, we are not, fully aware of what the impacts might be on this use, and so restricting it to the heavier commercial we feel is an appropriate step. Certainly, as the community sees this particular land use's impact over time, then things may change. The community could desire less restrictions, could desire more restrictions on that type of use and business. But also putting it into a conditional use category, with it being a brand new land use, we'd be concerned a little bit at the staff level that without knowing what its impacts on surrounding property would really be, it would be a very difficult case to try to process where the findings are directly related. Findings that the Board of Adjustment would have to consider for a conditional use permit are directly related to impacts on surrounding property, and so just don't feel comfortable at the staff level for several reasons on taking that approach.
So I think you said that liquor stores are allowed in C1 as conditional. Is that correct?
That is correct.
How many liquor stores are in that situation in C1s?
I'm only aware of one off the top of my head, and it's property that could probably qualify for a C2 zoning. It's actually up on Ellis Boulevard. There's a drive-through liquor store. There's at least one case where a liquor store was proposing to locate within a C1 district. and sought out a conditional use permit, and a very large number of residents of the surrounding area came out in opposition against that. So it can be a contentious type of land use in C1 districts.
For anyone trying to be in the C1 district that where the 1,000-foot buffer would disqualify them, would they be able to obtain a variance through the Board of Adjustment, or would the Board of Adjustment be able to rule on a variance on the 1,000-foot issue?
Yes, it is a zoning code requirement. So we're not, the cities can basically, by adopting this as a zoning code requirement, it's basically eliminating the state's role in that, enforcing any kind of separation distance. We're really obligated at the local level to decide locally what we want that separation distance to be. We are making, at least proposing, and if approved, would be making the decision to keep it at the same as the states, which makes it very easy for the industry to kind of interpret and make their decisions on. But it is a local law at that point, not a state one.
Right, and I just wanted to make clear. So if Mr. Bowman is saying that there's a lot of properties that don't qualify, and that's very restricting, some of those property owners would be able to still go to the Board of Adjustment to try and make their property qualify.
As far as I know, yes.
Okay.
And also the map that was shown up there before was before the walkable distance, right? That's more of a 1,000-foot radius type.
Well, like Eric said, the by foot way of measurement is hard to do with GIS and with computers. This was just a tool used for us to understand how that would affect the property. So it is just a buffer straight out, because it's hard on the computer to determine that by foot.
Anything else? Seeing nothing else, would somebody like to make a motion? And this is in two?
And yeah, so we want 3 motion.
No, 2.
You
Just add lawfully to the first one.
Oh, okay, yes.
So we can do this in
just
2?
add lawfully to number 1. Add lawfully to one of the first 2 motions, and that's it. Yeah.
You're doing great there, Dylan.
It's on C. Measurements shall be made along the shortest path between the demarcation points that can be lawfully traveled by foot.
Okay. No. So the phrase, if
So the recommended form of motion at the bottom of the revised staff report that you received today. So there's two motions, 1 and 2. The first one, the motion for approval of zoning code text amendment pertaining to medical marijuana dispensary facility as presented by his staff, with the amendment of the text to include the word lawfully, where Mr. Marcus mentioned.
somebody want to make these motions? Start with the first motion.
Sure. I will move for approval of the zoning code text amendment pertaining to the medical marijuana dispensary facility as presented by staff, with the amendment of the word lawfully being inserted between the words be and traveled in section 236B1C.
Do we have a second?
I second that motion.
Any discussion?
I guess I'd like to discuss the 1,000-foot buffer and some of the issues that Mr. Bowman brought up. One of the big problems with having a medical marijuana facility license is that there are so many restrictions on where you can be, not even just this, but if you look at the fact that it's a federal crime. I mean, regardless, the state has approved it, but it's still a federal crime. There are no lending institutions that will allow someone to take out a loan to buy or operate a marijuana-related business. It does not exist. It is a federal crime. The FDIC will not let banks do it. So then, as a person trying to get into the industry, you have to find a building that is owned outright, or you have to own it outright yourself. So it's not just that there's limited space here. It's that if you want to lease from someone in one of those blue areas on the map, that person has to own that building outright. It can't have a mortgage on it at all. And so that's why this is extremely restrictive. And it's not a fault of the city or the zoning code. It's just the fault of reality and federal law. And that's why I think it should be a little bit less restrictive to open up some more area for potentially people to come in, because you're talking about significant tax dollars here for the city. You're talking potentially $1 million plus in revenue for one dispensary per year. And I think that's something the city needs to consider. Not only that, but it is medicine. These are essentially pharmacies. And the way that the Department of Health and Senior Services has treated this is that this is people's medicine. And I think it behooves us to at least consider a less restrictive means to get people their medicine within the city limits and not have to rely on people driving unmarked vehicles, delivering them from Columbia or down from the lake all the way into town and back in and out, traveling miles with cars full of drugs. I would prefer it to be safe and in our city limits, and if we can do that in a less restrictive manner, I think we should.
Second that.
So, with that being said, is that something that you can also add as a motion to vote on?
I guess the question is what is the less restrictive manner that we want to vote on? Is it something like a conditional use? Is it reducing the buffer? Mm-hmm. I would be fine with the C1 conditional use. I understand that's not the staff's recommendation, but I would be for that, for amending the motion to that.
I'm in complete agreement with the C1 conditional, because even if it wasn't medical marijuana, the city has historically been such eye dollars and tea crossers that business has a horrible time trying to start up, especially flourish after they have started up. It's one little rule after another.
Don't you amend this?
You may want to ask. We'll ask.
You caught me too nice. The current motion on the floor can be amended by a motion, second, and a vote. So you vote to amend the current motion, and then you would vote to approve the motion.
So you amend, you have if I understood you correctly, we'll have a motion to amend. We either vote that up or down, and then we vote on the original motion as amended or not amended.
That's correct.
Hold on.
Oh, Eric, go ahead.
I'll address a couple things here.
Yep.
First, this was a two-phase incorporation of medical marijuana into the code. The first phase has already been approved, is on presented, and so the 1,000-foot separation is in the zoning code today. Okay? So that's just something to realize. I'm not saying it can't be changed. I'm just saying that it is codified. But a proposal could be made to change that, and that would go on up to the city council for their final review. Second, just to make sure everyone has a firm understanding of what a conditional use permit is. And so a conditional use is a type of land use that would be considered to be normally acceptable within whatever zoning district it is, being established as that conditional use. But a higher than normal potential for impact on surrounding property. Okay. And so the purpose of a conditional use permit is really to determine if there is a higher impact on surrounding property, and if conditions can be applied to that permit in order to, to reduce or eliminate that impact on surrounding property to an appropriate level. And so those permit applications are presented to the Board of Adjustment, not this body. So it would not be this body making a ruling on that. And the Board of Adjustment is a final decision-making body, so it's not, their decisions do not proceed on to a city council level. And so it's effectively assigning that land use responsibility to an independent board without oversight by the city council. The second is, as I mentioned, it might be difficult for that board to establish the impact on surrounding property for a use such as this. I would almost say that when establishing a conditional use, it would be good to have a good understanding of what the impacts on surrounding properties are going to be. Otherwise, there's little reason to establish it as a conditional use. It should be just permitted outright. If there's literally no way to mitigate the impacts of the use, or if that use has no impact on surrounding property, then there's nothing to really make it fall into that conditional category. I hope that's making sense for you. But beyond that, I'd be happy to answer any other questions you have as you consider this.
So what are review for me the usual businesses in a C1?
Okay, I won't read them all. I'll try to hit some of the more relevant ones. Are you looking for typical uses that are permitted in a C1 district? Bed and breakfast, offices, parking facilities, alcohol sales in restaurants, but not the retail package. So liquor stores are a conditional use in that district. Bars are a conditional use in the C1 district. Animal hospitals, banks, bakeries, food service restaurants, general retail, so just anything with a general retail category. And so
grocery stores that can sell alcohol and/or are they in
yes,
C1?
they're permitted use in the C1 district.
They sell alcohol. What about get-and-goes, service stations?
Yes. And so the threshold is actually 50%, and so a business that is selling more than 50% alcohol is classified as a liquor store. So.
Pharmacies are C1?
And so we don't have a separate item for pharmacies. It falls into a general retail category. So yes, permitted use of the C1 district.
So it seems like we're stigmatizing this right off the bat, saying alcohol is okay, that's it, in selling in liquor stores. Alcohol, regular drugs, opioids are okay, fentanyl is okay, but then if they're going to sell pot, it's not okay. I think we're approaching this more emotionally than we are straight out of business sense. I think if it was any other store, I don't think we'd have such scrutiny. We're worried about the neighbors going to say, and I know it's never going to pass conditional use, because every time you get public hearing, they're going to go voodoo, voodoo, bad, bad. But
so I'm thinking.
I don't know how to fix it.
Yeah, I'm thinking maybe it should be C1 or C2. It's still got the 1,000-foot restriction. Without condition.
Permitted use in C1.
Just permitted C1 or C2.
I just wanted to make sure you understood what the course process is. So. So the review process really is a business license type of review process or a land use review process. No, it would not come back in front of any board. It's an administrative action issuing a business license for that use.
The only advantage I see of making it restrictive, they'll just go right outside the county and with no code, and we'll lose that tax. That's the only advantage I see. Or go Callaway. I mean, that's even less restrictive.
Yeah, then I think I'd be in favor of it being a permitted use in C1 then. Just same as a pharmacy. So do I need to move to amend the motion first?
Yes.
All right.
No.
I don't think so at this time. I'm sorry.
All right. So I would move to amend the motion to include the amendment to be a permitted use in C1.
I'll second that motion.
Okay, so we have an amendment to the original motion and a second that that dispensaries should be allowed in C1.
We also have a motion about as by foot.
Including the lawful. Well, this is just a motion to amend that.
We back up and catch that. It's a layered thing. This is just to take it, change it from C2 to C1.
Right.
Okay. Any discussion? We're going to do. No. It's discussion here.
So, just a question. So by this motion, it's permitted in C1 and C2?
Well,
I want
the motion is.
Okay,
the
I just
motion
wanted
is
to clarify.
amend the original motion, and then we vote on the amended motion.
Yes.
Right.
So we're voting on the amendment.
Right now, Mike, it's just the amendment that Blake proposed to include it as a permitted use in the C1 district.
C1.
And the
And
C2
if,
still...
if that's
the C2
approved, then
still
it goes,
exists. Okay.
yeah, onto
Okay.
the original motion.
Okay. Any discussion? I think we're going to do this by roll call. I'm going to ask that we do this by roll call.
Cotton. Deacon.
Yes.
DeToy.
Aye.
Lester.
Yes.
Mahoney. Marcus.
Aye.
Vaughn.
Aye.
Vought.
Aye.
Passes unanimously. Okay, so now we're going to go catch the first motion as amended.
All right. So we would move.
It's already
We've
been
already got it there.
made,
It's
so
there.
it's
All right.
either
So
further
what
discussion or
we've now
vote.
added
Perfect.
C1, permitted use in C1 to the motion that says lawfully.
Yes, I move that.
Okay, we have that motion, we have that
It's
second.
already been moved.
Any
Amended.
discussion on that? Seeing none, we'll vote on this. We're going to, I
roll
don't.
call again?
Yeah, let's do this roll call again, please.
Cotton.
Yes.
Deacon. DeToy.
Aye.
Lester.
Aye.
Mahoney. Marcus.
Aye.
Vaughn.
Aye.
Vought.
Aye.
Okay. The first motion, as amended, has passed. Now we need to go catch the second motion.
Well, I tried to describe the first one. I'll just go through and describe the second one just to make sure everyone understands. And so the reason for the second motion is just to align the language with the final language that came out of the Department of Health, and to also technically include the transportation facility. They put a fifth land use category on us at the last minute, so we're going to fold that in there. And it's not being advertised, although we've been very, very upfront with this publicly, as being aligning with the state regs. It's the attorneys tell us it needs to be done separately as what's called a bill amendment, and so to respectfully request a motion as outlined on the staff report.
Okay, we need a motion.
I'll move to approve the bill amendment to the zoning code text amendment pertaining to the medical marijuana transportation facility and distant measurement parameters regarding the 1,000-foot separation as presented by staff.
Okay, we're going to skip the roll call on this one, I think. All in favor?
Aye.
Any opposed? Motion passes. Other new business. Any other new business?
No other new business. We're on to.
I'm just making sure where we.
No, I
there's
think
nothing popping up. Any other business?
So other business is up on the screen, 2 items. The first, just update on prior cases. All 3 of the cases listed there, the Highland Village subdivision. The medical marijuana text amendment for the Phase 1 that we discussed, and a street name change for a short alley located just on the other side of the highway from downtown here. They were all approved by the City Council. I'd be happy to go into more detail on any of those if anyone needs any. So,
And a comprehensive plan update.
Okay. Well, first, I just want to thank everyone who participated in the work session that we had on May 9th. We received a lot of valuable feedback, and it allowed me to strengthen our work plan moving forward with the community workshops for the comprehensive plan update. So I just wanted to give a quick little update as we move into Phase 2 of the comprehensive plan. So we've been conducting stakeholder interviews. Those are one-on-one interviews to go into various planning topics with community stakeholders as a combination of people from the community and members of our staff. And then due to the tornado, we've pushed back the community workshops that we discussed in May. So now those dates are July 30th, August 29th, and September 19th. We can send out a flyer regarding those workshops to you guys. This is a really good time for people to inform the planning process, and we really want their voices to be heard. This is an opportunity for you guys to also be a really good advocate for this planning process. I encourage all of you guys to attend at least one of these meetings, and I would also like for you guys to share the fact that we're hosting these workshops with everyone you know. Anyone who works, plays, or lives in Jefferson City is encouraged to attend these workshops. And if you need any help with like language for social media or emails, or want copies of the flyers to distribute, you can email me and I can give you a communications plan packet that we have prepared. That's it.
Any questions? Okay. I think at this point, if we have another, or you guys have anything else?
July 15th. The public hearing and vote for City Council will be July 15th for medical marijuana regarding the dispensaries and the amendments we made today.
As amended. All right, I believe then, if we have nothing else, we're adjourned. Thank you all very much.